Good day, everyone. I'm Lauren Maxey here with your daily counsel update for the day. Wanted to touch base today on how to save the house from estate recovery. It's a very, very common concern we come across in the elder law planning practice area. If someone goes on Medicaid for skilled nursing or assistance with paying for long-term care, a common concern that we have is, how do we save the house? What type of proactive planning can we do to try and protect that asset? Very commonly, the house is what many individuals have saved and contributed towards their entire life. So it's one of our biggest, most built up assets over time. And again, there's some proactive planning we can do with clients to try and save that as much as possible. So number one is, if we're in prospective planning mode, which means over 5 years out from potentially needing Medicaid, many more options are available. One of the most common things we do in that scenario is we take the house and we deed it over to a Medicaid asset protection trust. Now, this is a very particular type of trust, structured in a way as to not negate Medicaid benefits down the road, but we take it, we deed it over there, and typically trustee, most often children, are the ones that manage it while it's over there. Now, why I like this is potentially it just opens up more options down the road. The children, 4 years down the line, may be able to sell the house, privately pay for care for some extended period of time. In their discretion, what they see as best, they're able to sell, liquidate that house, and use some of those funds to take care of mom or dad in need of that long-term care prior to going on to Medicaid, or even after going on to Medicaid to supplement what Medicaid may be providing. So through that prospective planning, the sooner the better, more options available for how we can use the asset there, because you're able to gift it over to that trust. It's a transfer for less than fair market value, so it's technically a gift from mom or dad to that trust. But because we're outside of that 5-year look back for Medicaid for the aged, blind, and disabled, you don't have to worry about that being a quote unquote sanctionable transfer because it was a gift. So you're good on that. Now, number two is, if we are within potentially 5 years of needing long-term care, one of the things we look at is essentially, it's called adding a right of survivorship to the house. So putting a new deed on the property, it's essentially mom or dad or whoever is the property owner selling. So it's a transfer for fair market value, selling an interest in the house to one of the children and having a right of survivorship on it. So by selling the property, again, it's not a sanctionable transfer. It's not a gift. You don't want to do any gifting during that 5-year look back. And by adding that right of survivorship, you're eliminating the property from sitting there and being available for estate recovery after someone passes away and Medicaid comes in and becomes a creditor of their estate. So incredibly important. Always look at what are the options there. Again, it's never too late to plan. So this is something we talk a lot with clients about. Lots of different strategies. Even if someone's already on Medicaid, we may be able to play with stuff there. Again, it gets a little more complicated if someone's already receiving Medicaid benefits, but there are options. So never too late to plan. Give us a call. We're happy to discuss. Knowledge is power with this stuff. So knowing what are the options, allowing our clients to make those informed decisions of what's best for their loved ones is what it's all about. I hope that helps, gives you some food for thought to consider. And if you need anything, give us a call. I hope y'all have a lovely rest of your day.